Today we are going to discuss about oral instructions and the dilemma in the oral instructions. So we'll see what are instructions, what are oral instructions, and we'll be seeing the same in the context of a construction contract. Basically, we'll be dealing with the standard form of contracts like JCT and FIDIC. So we start with what are instructions of an architect or the instructions of an engineer or the contract administrator. When we say engineer, architect, or contract administrator, we mean the same thing. So if you look at the forms of contract, basically the definition of instruction is not found. So what is an instruction? An instruction in the context of a construction contract means an order, a direction, or information given by the engineer or the architect or whosoever is administrating the contract, which the contractor is bound to follow as per the contract. So now we go on to other features of an instruction. So what are the features? The contractor can take instructions only from the engineer or the architect or the contract administrator. No, the clerk of works or any other clerk cannot come, a personnel cannot come and just start issuing instructions to the contractor. The power of issuing instructions is directly derived from the contract. Basically, the contract, a construction contract, the conditions, they give the power of issuing instructions and the obligation to the contractor of following them. Other feature of the instruction is the engineer or architect cannot give instructions out with the contract. The instruction should be within the scope of the contract and should not be something out with the contract. An interesting part is the client cannot give instructions to the contractor as per the contract. Basically, instructions are work related. The client can give instructions regarding permits or other things which he is obliged to take. He can give instructions regarding those, but regarding the works, no, the client cannot give instructions to the contractor. Now a big question rises, then why give the unilateral power of issuing instructions to the engineer? Basically, as we all know that all construction projects are complex and unique in their identity. Every construction project is unique. We don't see two projects of the same type. You know, duplicate them. And since a construction project is complex and it's huge, you can say sometimes, complete details and requirements cannot be incorporated. It's impractical. You cannot incorporate each and every detail in a contract document. Now, due to this complexity and need of change, express powers of issuing instructions are given to the engineer. Now, a construction project may have a time duration of 2 years, maybe 3 to 4 years. Since inception, what you say, since the project is being designed and to the construction stage, still that may take another period of time, may pass or lapse. Now during this period, there may be some technology changes, there may be some new materials coming in the market, or there may be some new requirements being generated in the market. which may require a change in the construction project. Now, to have this flexibility, the engineer is issued or given the power of issuing instructions to the contractor for such changes. Also, instructions can be given in emergencies. So, since most of the time the engineer is based at site, he has those powers to give instructions. Now we have discussed this. Engineer can direct a contractor to do things which may not be specifically included. Now an interesting part comes that if not this power, then what will happen? The contractor can insist only to work as per the contract. Now this may lead to a very difficult situation. There may be a contract or a project designed 2 years earlier on which construction has started after 2 years, and the client finds out something like the project needs some change so as it can be more lucrative or acceptable to the market. So now if the power of issuing instructions are not there, then it will be very difficult for the client to change or to order the contractor to change some of the aspects of the contract of the project. A difficult situation really for the employer. Now, instructions to do what? For what works instructions are given? Basically, we will just outline some of the purposes for which instructions are given. Now, postponing of possession of the site. It may be agreed in the contract that the possession of site to start works will be given on a certain date. But due to some reasons, the employer may not be able to give. The architect basically in the JCT forms of contracts has the power of postponing the possession up to 2 weeks. The same can be said in FIDIC also, but it's not very clear in FIDIC. Now, an engineer or architect can give instructions related to QA, QC matters. They can give instructions of making good some defects. They can give during the construction of the project. They can give instructions to rectify some bad workmanship. They can come and check or give instructions to remove material from site, and they can also give instructions to open up some works, like some hidden to check whether that work was done properly or not. Or they can give instructions for testing of materials. As we discussed, they can give instructions to remove work off-site, which is not in accordance with the contract. They can make... now, during the maintenance period, the engineer or the defect liability period, maintenance period, or so in that period, the engineer or the architect can instruct the contractor to make good defects or not to make good defects if the defects are accepted by the employer. The engineer or architect can ask to carry out variations in case of the contractor has made some error. They can ask him to carry out some remedial measures or remedial works. Then, of course, they can ask to carry out variations, changes, as required by the employer. But these should be within the scope of the contract. the, the engineer can ask to submit a proposal or quotation for these changes, or any necessary directions can be instructed to the engineer contractor to enable him to carry out and complete his works. Now, the form of an instruction, basically there is no standard form of an instruction, but an instruction should be in writing, can also be oral, as discussed below. We'll be discussing that. And it should be clearly spelled out as an instruction. It should be clear. And it should say, yes, this is an instruction. Its intent should be clear and it should be unambiguous. These are the characteristics of an instruction. Now we move to what is the effect of an instruction. So what is the effect? When an architect or an engineer gives an instruction, so what happens? So once the instruction is issued, the contractor is under an obligation to follow the instruction as per the contract. If he doesn't follow it, and if he refuses to abide by the instruction, the contractor will be in breach of contract. In case the contractor refuses to follow an instruction to carry out some works, the CA can get the instructed works done by a third party at the risk and cost of the contractor. Of course, these works should lie within the contract and within the scope of works of the contractor. The architect or the engineer can ask to remedy some defects or to rectify some defects or to carry out some works which he deems to be within the contract. If the instruction orders for works to be done which are beyond the scope of the original works, the contractor can refuse to follow such instructions, and he can always give reasons for the same. So a contractor is not obliged to follow instructions which are out with the contract. Now we come to oral instructions, which is basically the topic of this discussion. As we have discussed, instructions can be oral also. FIDIC and JCT very clearly they mention that instructions can be given orally. An oral instruction is an instruction only when it is given with an intention of giving an instruction and should be clear and unambiguous. Sometimes you will see that the engineer asks the contractor to carry out some works. The contractor may deem them to be extra works. They may in fact be extra works, but the engineer or the architect may not think that those are extra works. They may think that they are included in the contract. Now, most of the standard form of contract allow, we have discussed this, to issue oral instructions. Now, as per the mechanism which are, basically instructions should be in writing, but since these standard forms of contract do allow oral instructions, there is a mechanism to get it confirmed in writing. So once the engineer gives an oral instruction, it has to be confirmed by the contractor. He should send in writing to the engineer saying that, okay, I have received an oral instruction from you and you please confirm it. Now, if the engineer confirms it's well and good. If it doesn't confirm it, the FIDIC and JCT, most of the standard forms of contract, give the contractor some period of time during which the engineer, some period of time during which these instructions have to be confirmed. And if these are not confirmed within this specific period, the instructions are deemed to be written instructions. Now, what if oral instructions are not confirmed? Can the contractor claim that they are instructions? Now there's a big debate on the big dilemma on oral instructions if they are not confirmed. Now oral instructions, if any, can only be deemed to be instructions in writing on the silence of the engineer and architect. Now, to note, we have to note and note it very carefully that any passing reference of the engineer cannot be regarded as an instruction. Why I say this is because the project manager or the site team may be under pressure to progress the works. And they may be in good relations with the engineer or the architect, and they may be urged to progress the works, or in some cases, they may just, what you can say, not confirm the instruction, oral instructions, and go ahead with that. It's very dangerous. And the second thing what happens is, there is a daily contact between the engineer and the contractor. So what happens is, most of the times the engineer will say something to the contractor, okay, buddy, do this, do that. But certainly such passing references cannot be considered as oral instructions. Now, as we can see, if if the contractor sends a confirmation of verbal instructions, as usually it is said, and the engineer does not confirm them on these passing references, these will not be deemed to be an instruction, because the engineer is required to confirm oral instructions. Means instructions which he has given orally with an intention of giving an instruction. If there is a passing reference or just a remark, or maybe just something saying, okay, you need to do this, you need to do that, or you do that, maybe the engineer may be pressing the contractor to do something. But unless and until the engineer gives these oral instructions with an intent and with a clarity, then only these can be regarded as oral instructions. Now the dilemma is, see, if this, let us say the architect has given some passing remark and he wants the contractor to consider it as it having a force of an instruction, but he doesn't want to say that these are oral instructions. This usually happens in contracts. The engineer or the architect may pressurize the contractor in doing some things. And now the contractor does not follow these, and it turns out to be that these are oral instructions, then the contractor will be in breach of contract. On the other hand, if the architect or the engineer is silent on these references or some oral utterances which he has said during a site visit or any meeting, informal meeting, he may not confirm them and he may just sit silent on them. But if the contractor deems these to be an instruction after a certain period specified by the contract, then certainly the contractor will be in breach of contract again if the architect or the engineer alleges that he has not given any instructions. Now, what should the contractor do in such situations? First, the contractor should affirm that the person giving the instruction has the delegated power of giving an instruction. A contractor cannot take instructions from anybody. It has to be a person who has been delegated by the engineer to issue instructions. Further, it is strongly advised that the contractor should first ask the engineer clearly if he has given an instruction orally. Then the contractor should write to the engineer giving details of the instruction received and also of the timing when he received such an instruction, and mention clearly that the instructions need to be confirmed in writing, failing which the contractor has no intention to act. Also, the contractor should state his intentions of claiming extra payment. The intentions of claiming of extra payments for carrying out any work instructed in the contract orally by the engineer should always be mentioned. Now, points to note. We just come around. Acceptance of works orally does not show any implied promise to pay. Taverner versus Glamorgan. Now, this was a case in which Taverner, the contractor, alleged that the county clerk had given the contractor some oral instructions. It was basically some cladding on the building. So the county clerk was empowered by the contract to give instructions. The contract said the instructions should be in writing. If any variation should be in writing. Now, the county clerk gave orally some instructions, and to the CEO of the contractor carried them out willingly, and claimed on money for those variations. The county clerk did not pay. They went to the court. The court decided, since there was no written instructions, so no payment. Sorry. Now, the contractor cannot recover from the client if he carries out works beyond the scope of the original works, although these have been instructed by the engineer. So, if there are instructions beyond the scope of the original works and the contractor carries them out, he is not entitled to any payment. And one of the interesting cases is Stockport MBC versus O'Reilly. Now, O'Reilly were the contractors, and they carried out works instructed by the engineer, who instructed them to carry out works in phase-in instead of dates, and ultimately these works are out with the contract. The court decided, okay, now these works are out with the contract, and the engineer or the contractor cannot saddle the employer for the responsibility of these works. The contractor carried out, the contractor should have known that these works were out with the contract. Now, coming to a case where a contractor uses something better than what was specified in a contract. Basically, the contractor cannot recover any payments if he uses better quality of materials. And now I'm bringing these points here because such things may mostly are instructed orally. So, now if you have some contractor, he carries out work, or uses some material of better specification, which is far better and expensive than what is specified in the contract, Then unfortunately, it, it was held in Holland versus Hannon versus Cubit and Cubit versus WHTSO. The contract was not completed because the contractor did not work as per the contract. So what if he uses something better? It was not in the contract what you had agreed. So the contract is not complete. No entitlement for payment. Now coming to the conclusion of all of this, oral instructions, if they are not confirmed, the contractor may not have a claim for extra payment on the mere basis that he has carried out extra works. There should be something which has made him to carry out these extra works. There should be some order. And if there is an oral order and the contractor claims on this oral order, the burden of proof will lie on the contractor to prove that he has carried, that oral instructions were given in the first place and that extra works were carried out on those oral instructions. So oral instructions basically are a dangerous piece of work in contract, and I've just told you what was the dilemma in that. Hope this has benefited you, and I'll be coming in with more of construction contract related issues, and hope we meet again soon. Thank you.